Yeah.
Gosh, it's just like the old days. They stopped talking.
Well, it's
Sorry, before we start,
yes,
you
sir?
have
Yes,
mine
of
too.
course.
Not trying to take anything away from you.
I was about to welcome you. Your Excellency, the Governor of New South Wales, Margaret Beazley, AC, KC, and of course former President of the New South Wales Court of Appeal, and Dennis Wilson, former Chief Justice Murray Gleeson, and former Chief Justice Jim Spiegelman, the Chief Judge of the District Court, the Chief Magistrate, current and former judges of the court, including my friend and colleague, the President of the Court of Appeal, and the Chief Judge in Equity and the Chief Judge at Common Law, current and former judges of other courts, the Honourable Keith Mason and Larissa Reid, the editors of the wonderful book about to be launched, distinguished guests, members of the Diplomatic Corps, the Academy and of various churches, members of the legal profession, all. Oh, and yes, and yes, I won't start again, and I won't be permitted to forget the Chief Justice of the High Court, Justices Gleeson, Jago, and Beach Jones. Oh dear. Welcome, a special welcome to you four. I was saving you up for last too. Well, it is an enormous honour and pleasure to welcome you all to this significant component of the court's bicentenary celebrations. But let me begin by acknowledging the Gadigal of the Eora Nation, on whose traditional lands this court stands, and paying my respects to elders past, present, and indeed to all Aboriginal and Torres Strait Islander people here or on the live stream. It was in this courtroom some 25 years ago that the first ever public welcome to country was given by Auntie Ellie Golding at the invitation of then Chief Justice Spiegelman, and ever since that time, an acknowledgement, or where available, or welcome to country, has been an important feature of this court's ceremonial sittings. This ceremonial sittings and events such as this. This evening we gather for two principal purposes, if one can have two principal purposes. The first is the launch of our magnificent new history, edited by Keith Mason and Larissa Reid. I'm biased, which is not a good characteristic for a judge, but it is a magnificent work, and on behalf of the court, I wish to publicly express my deep gratitude for what has been a Herculean effort led by both Keith and Larissa in bringing it to fruition. Keith will respond on his and Larissa's behalf after Jim has officially launched the book. After that, I will call on Her Excellency to say a few words about what is now outside the Banco Court. And as you may have seen, there is a great deal outside. There's what we call the History Wall, there is the Supreme Court Gallery, there is the display of ceremonial robes, there's the Rafferty collection of court drawings illustrating leading cases in the 1980s, and some of you will have seen Simon Fieldhouse's historic group portrait of the judges of the court in this bicentennial year, and Simon has gifted the original of that work to the court, for which we are very grateful, and I hope he's here. I think he's here today. The area outside the court will become the heart of the court's public and civic engagement with a strong historical emphasis. That is all quite deliberate, because the philosophy underpinning our approach to the bicentenary this year has been to recognise the importance of this court as a leading civic institution and to ensure, as far as we can, that not only members of the legal profession, but more importantly, members of the broader community are aware of its role in our democracy. Part of building respect for the court is ensuring that people understand what it does, what it has done in the past, why it exists, and why its maintenance is fundamental. After Her Excellency's remarks in respect of the gallery and the wall and the other features outside, I will invite her to cut the ribbon to open our gallery and launch the history wall. I do want at the outset, though, just to acknowledge a number of people in addition to Keith and Larissa. First, the court appointed about a year ago, or under a year ago, Bicentenary Project Officer, Ms. Sophie Howard, who has been the sort of creative genius behind the gallery, much of the wall, and the extraordinary public displays. And she's brought huge energy and skill and style to enhancing the court as a public institution. I'm very grateful to her. Secondly, I acknowledge and thank and I'm grateful to Christopher Winslow, the court's public affairs officer, who has had a role in all aspects of our bicentennial planning and bringing it all to fruition. There are many others who have contributed, but I particularly want to mention Sophie and Chris. Thirdly, I want to acknowledge my indefatigable associate, Edwina Chapman, and Mr. Jerry Thorofsky, who have put this function together with consummate skill and attention to detail, as they do with all of the court's public engagements. Now, turning to the business of this evening. For me, it was not a difficult decision to identify who should launch the history, as the second paragraph of chapter 1 of the book says, 17 May 2024 is the 200th anniversary of the first sitting of the Supreme Court of New South Wales. Only a handful of nations have such an old judicial institution, as Spiegelman CJ liked to remind new legal practitioners. It was Jim Spiegelman who really raised the historical significance of a court of this longevity and tradition and integrity, and that, as well as my deep respect for him as a leading public intellectual, made it an easy choice. I'm not going to introduce him. There will be no one in this room who doesn't know who he is or what he has done in his outstanding public career. So without further ado, I invite the 16th Chief Justice of New South Wales to address us.
Thank you, Chief Justice Belv. It's quite amazing how you managed to engineer this project. I could never get this kind of money. But anyway, in preparation for this occasion, I read the text in proof copy. The process of reading was a delight. The writing is clear, devoid of cliches, and the array of photographs enlivens and adds depth to the text. It is a magnificent testament. I must say, when I had the proof copies, that was an excellent testament. But when I saw the final book, I changed excellent to magnificent, which I think it is, of the significance of the bicentenary of the court. As is recognised in the book, my term of office, I delivered speeches and published articles to which Chief Justice referred, over a wide range of the aspects of this court's organisation activities and hints and the importance of historical continuity. That was one of my dominant themes of 13 years of public engagement as Chief Justice. From my swearing in through the 175th anniversary of the court, and in every one of the 900 or so times I repeated my standard address to the boredom of my colleagues at admission ceremonies. When I come to meet my maker, I will have to explain why I admitted about 15,000 new legal practitioners. My only defence will be that half didn't take out practising certificates. But despite that, my past immersion in these very topics, reading this volume has been revelatory. I learned something new on virtually every page of the text. And I congratulate and thank the authors of the respective chapters, and especially the editors, Keith Mason and Larissa Reed, who brought it all together. There's one quotation which I had not come across before, and which could serve as an epigraph for this volume. Sir Victor, epitaph is a bit different. Sir Victor Windeyer once commented on the traditional clothing of lawyers and judges. He said, "The observance of old forms and customs is not simply a conservative adherence to usage. It is more, for it is a manifestation of the continuity of the law of the land. The present is visibly linked with the past as a firm basis from which the development and reform of the law can proceed in response to new social needs." As I said, this is an epigraph for this entire volume. It applies well beyond court dress. It applies to almost all aspects of the legal system, so comprehensively covered in this book. Beyond the detail, one can deduce two overriding consequences of continuity. First, there is an embedded wisdom in institutions which have grown and developed over long periods of time. Secondly, institutional longevity is a defining characteristic of a successful society because stability enhances the level of trust in that society. An excellent example of the social contribution of the continuity of the law is manifest in two related judgments of Chief Justice Forbes, the first Chief Justice of the Court. Under the New South Wales Act of 1823, which established both the Supreme Court and the First Legislative Council, which could enact legislation, however, all legislation was subject to a ruling by the Chief Justice that the Act was not repugnant to the laws of England. In essence, this was a one-sentence constitutional Bill of Rights. Permit me to observe that I've written about common law Bill of Rights, and that's inherent in this original provision. A year after the court commenced, Forbes had to rule on Governor Darling's attempts to control the increasingly intrusive local media, particularly The Australian, established by the first two London qualified barristers of this court, Wardell and Wentworth. That act required all papers to be licensed. Forbes CJ struck it down as repugnant to English law. The governor then imposed a stamp duty on newspapers which would have crippled their operation. Under the New South Wales Act 1823, the Legislative Council had authority to impose taxes for certain purposes. The Stamp Duty Act expressly stated that its purpose was to raise funds for public works. Forbes determined that the true purpose of the tax was to destroy certain newspapers. It was struck down. Talk about activist judges. But freedom of speech was established as a fundamental value even when we were in essence a military regime. From the outset, this court was a constitutional court. I note that it took the High Court about a century to reach similar conclusions about the Constitution of the Commonwealth. The common law of Australia has long since developed from the common law of England, as everyone in the room knows. However, there remains ties that retain utility. A personal example is that both I and Chief Justice Bell are members of Lincoln's Inn, as Chief Justice Forbes was 2 centuries ago. Each of the 17 separate chapters in this book cover the historical origins of the subject topic and set out how that aspect of the law has adapted to change social circumstances. The ability of our legal system to innovate and reform was apparent from the outset, as classic example, convicted felons would not sue in English law. That wouldn't work in a convict colony. This volume definitively identifies the ability of the court to ensure that its procedures and substantive law remains relevant and effective. I accept that this process was not without diversions and delays, but the fundamental focus of the book is the Supreme Court. However, it is also about the role of law in our society and how that society has changed over time. As such, it's not just a legal history. I have no doubt that it will be used as an educational text for a much broader sphere than legal education. That is particularly apparent in the chapters such as those on famous criminal cases and Indigenous peoples and women. Each of them reflects the prejudices of the time and shows how attitudes have changed and court practice has adjusted. The understanding of continuity in the structure and the content of the law underpins the stability of our social life in all its manifestations. That common knowledge is reinforced by the inheritance of legal terminology, which does not fluctuate in the confusing manner of other spheres of public discourse. 2 recent examples will suffice. For most of my public career, the word elite was a left-wing term of abuse. It has transmogrified into a right-wing term of abuse. More recently, the word woke, which began life as a reference to an awakened recognition of racism by black Americans, has been taken over by those who think that such recognition is either wrong or at least has gone too far. Perhaps we should be grateful that woke appears to have completely replaced the sarcasm of politically correct as a term of abuse. I recommend this book to every practicing lawyer and judicial officer. I have one minor qualification. In the overview chapter of the second century of the court, there's a discussion about the jurisprudential distinctiveness of New South Wales. I refer to the strength of equity scholarship over the entire 2nd century, perhaps most clearly under Chief Justice Jordan and thereafter. This state and the court, as everyone knows, retained the structural separation of equity from common law for almost a century after their merger by the Judicature Act in England, which were quickly adopted by other states in Australia. After New South Wales finally brought the jurisdiction together, there remained a passionate resistance in this state to any suggestion that this could affect the substantive law of equity. This was rejected as the fusion fallacy, an evil term. This was part of my education at the University of Sydney Law School, where the lecturers included Roddy Marr, John Lehane and Bill Gummer. I was surprised by a passage in Chapter 2 on the 2nd century in this book, which characterised the commitment to the tradition of equity as a preference for, I quote, historical distinctions, unquote, and contrast with, quote, coherence and rationality, unquote. My own background rejects the suggestion that an emphasis on the distinctiveness of equity was either incoherent or irrational, let alone both. I knew that the co-author of this chapter, Keith Mason, had bitten from the restitution apple. My surprise arose because the other alleged co-author of this chapter was said to have been Justice Mark Leeming, the very editor of the updates to the sacred texts by Marr, Gummer and Lehane. I do not accept the attribution of co-authorship in this respect. This book provides an excellent and comprehensive background to the celebration of the court's imminent bicentennial. It adds depth of a kind that the court did not attempt in the celebration of the 175th anniversary in 1999. Those who were present for that ceremonial sitting will recall 2 distinct features. First, Mr. Barker QC and Ms. Hole, respectively the presidents of the Bar and of the Law Society, surrendered their usual role of addressing the court at a ceremonial sitting. The former Prime Minister, Gough Whitlam QC, spoke for the Bar, and the serving Prime Minister, John Howard, formerly a solicitor, spoke for the Law Society. Secondly, before the addresses by Whitlam and Howard, an Aboriginal woman delivered a welcome to country, as the Chief Justice has mentioned. Practice was virtually unknown in 1999. The book I'm launching describes the reaction of the overflowing Benko court as you could have heard a pin drop, and I confirmed that I had never experienced silence like it. I'd only told two people of this addition to the usual agenda: Keith Mason as the second in seniority in the court, and John Howard, who had recently been the target of Indigenous protests. I knew I didn't have to seek the consent of my former boss, Gough Whitlam. This was the first time, as Chief Justice mentioned, that such a welcome had been delivered, and the President of the Legislative Council later informed me that the court's precedent was what enabled this practice to be adopted by the New South Wales Parliament. Finally, I'd like to repeat the reference with which I concluded my address at the 175th anniversary. In his judgments, Chief Justice Forbes had acknowledged that for thousands of years before the arrival of British justice, Indigenous Australians made and enforced the laws in this land. That is a recognition that the court, admittedly after a long gap, now acknowledges as recognised in the Indigenous chapter in this volume. There's no tradition about a physical act to announce the launch of a book. Not cutting a ribbon, not smashing a champagne bottle, which the Chief Justice would not permit, and not even a toast. As we are in a court, I recognise and thank the editors Keith Mason and Larissa Reid with a bow.
Still got it. Now it's my pleasure to call on Keith Mason. He was, of course, for many years President of the Court of Appeal, and before that for many years Solicitor General of New South Wales. It's been, for me, an absolute delight to work with Keith and Larissa in the production of this book. They have been unfailingly wonderful in every respect. This book has been entirely self-published by the court under the helm of Keith and Larissa, and for a book of this size, quality, to have been so self-produced and self-published is ultimately a tribute to both of them. So Keith, it's with great personal pleasure that I invite you to respond.
Thank you, Chief Justice Bell. And thank you, Jim Spiegelman, my judicial colleague and friend, for your kind remarks. Thank you all for coming this evening. My co-editor, Larissa Reid, and I are very excited about this book. It has been morphing since 2019, when it was formally commissioned by Chief Justice Tom Bathurst. Justice Mark Leeming tapped me on the shoulder only 24 hours after I was overheard wondering about a project to follow my completed biography of Sir Frederick Jordan. For this book, I was given a free hand, save for an immovable deadline. Delivery had to occur before the court's bicentenary in May 2024. That date seemed light years away at the time of conception, but I was then quite ignorant about what lay ahead with the production of a work such as this. It's totally different from writing an appellate judgment. There, one focuses on the competing arguments of counsel before circulating a draft to one's colleagues. They are invited to suggest amendments, but otherwise given the option of agreeing or writing separately for themselves. The book quickly evolved into a highly collaborative project as topics were identified and specialist authors were approached. Larissa's many contributions quickly revealed the essential role that she would play in the project. She accepted my invitation to become co-editor with the encouragement of Vanessa Blackmore, the manager of the Law Courts Library. I'm very grateful for this and for the devoted research assistance provided by the 6 reference librarians who have become friends. Librarians and archivists at the Bar Library, State Library, Museums of History and the Parliamentary Library also contributed greatly. The editors made some exciting discoveries as we rifled through long-buried primary documents. For example, the declarations against the Roman Catholic doctrine of transubstantiation required to be made by the early judges. Mr. Justice Burton's note of the Myall Creek verdict with the words "not guilty" then crossed out and replaced by "guilty." Alfred Stevens' snaky note about his colleagues in his personal copy of the Law Almanac for 1865. The commemorative postage stamp issued at the court's 150th anniversary. Larissa's talents as a researcher, writer, tireless fact-checker, and gently relentless co-editor have shaped the entire work. Countless hours were spent searching for and unearthing buried nuggets. To give but one example, she discovered a newspaper report about the mixed reaction of women to the legislation allowing them to sit on juries. You'll see on page 213 that Mrs. Peg Davin, hotel employee, was opposed to this reform. She said, "I think women would be better sitting on a clutch of eggs than on a jury. They would probably produce more. It's a bad idea. 1 or 2 women might have the brains for the job, but the majority of women have not the calculating scientific mind which would be needed."
Brainwashed.
I would hope that even a man could have a chuckle at this utterance in 2024. Peg Davin spoke in 1947, which happens to be the year of my birth. It's one of many indications that so much has changed in the law since 1950, as readers will discover. The editors drew assistance from the many talented folk in the chambers of the Chief Justice, as well as officers of the Court and of the Department of Communities and Justice. Their contributions are identified in the preface, but Chris Daith, Rebel Kenner, Nick Sanderson-Goff, Nathan Gray, Dan Bieri and Sam Goldberg deserve special mention. Chris Winslow, the Supreme Court's media manager, kept the project moving forward. Together with my co-editor, he constantly fortified the health of the embryonic literary infant, trimming rough edges of language, adding sugar sometimes, spice at other times, here and there, and identifying some dangerous nutty additives in what was in the text originally. You will see that there are many fascinating pictures that enliven the text. Finding them and obtaining permission to use them was a Herculean effort. Some that were chosen for inclusion were not available to be used. Integrating them into a still evolving text was an added challenge. So I wish to single out for praise and thanks in the artistic, pictorial and design department, Sophie Howard, Kylie Malkin and Larissa Reid. Sophie also designed the chapter motifs using decorative elements from the King Street Courthouse. She managed all of the image acquisition and permissions process and deployed her artistic eye to assist with final image selection. Kylie Malkin is a graphic designer, and I hope you'll agree that the end product is quite striking. We're also indebted to Una Doyle, Kate Lumley and Philippa Breeden of the Judicial Commission for helping with the exciting chapter about the Judicial Commission. That was my favourite. with a bit of help from Terry Sheehan, and for the copy editing that they did. Glenda Brown and Juliet Brodsky assisted with the index. The book is printed by the proudly Australian Ligari book publishers. Chris, Sophie, Kylie and Marissa were heroic in the stressful weeks of final production when I elected to go away on holidays. A few minor setbacks were encountered. They included a flood that put the library out of commission for weeks. There was also a departmental refusal to release documents about the creation of the Judicial Commission in 1986 that was overcome by personal resort to appellate rights under the state's Freedom of Information legislation. Herodotus was described by Cicero as the father of history, but even Herodotus drew on Homer, that blind nodder who may or may not have been a real person. The point is that every historian stands on the shoulders of others. This book acknowledges a great debt to the giants of the comparatively recent field of Australian legal history. I speak of Alex Castles, Bruce Kircher, and John Bennett, not overlooking Greg Woods, Jeff Lindsay, and John Bryson. The work of other historians of the court is acknowledged at page 64 of the book. Several of them are judges. One who is not is Dr. Heather Roberts, an academic who has published widely on the genre of speeches given at judicial swearings in and swearings out, including what they reveal about changing enthusiasms. Most published writing about the court's history stops about 50 years ago. Yet probably more has changed in that period than in the preceding century and a half. Much information about the recent past therefore had to be gathered and sifted. Writing about this era produced additional challenges. I'm not so much alluding to the risk of actionable defamation as the likelihood that there will be countless witnesses to both the good and bad deeds of those who are still living. One's own professional experience and biases will always influence what matters are deemed worthy of discussion or comment. A recent letter writer to The Economist, who was also born in the 1940s, observed that much of his own past is now history. This truth is both a challenge and an opportunity. Sir Leslie Herron was Chief Justice when I was admitted to the bar in 1972. Yet some in this courtroom today will not have been born when Lawrence Street and Murray Gleeson were Chief Justice. Looking around, there won't be many, but certainly some. For me, it's been an added pleasure to record for posterity some stories about Jerry and Malcolm McClelland, father and son, who were each the Chief Judge in equity. Harold Glass's so-called Nello Gravy Train, Kirker 1970. The 1992 Special Sittings Blitz, and the Spycatcher case, when the formidable Mr. Justice Philip Powell presided over a trial being reported daily in the London papers in which the defendant was represented by a solicitor aged 28, Malcolm Turnbull. The research for the chapters on women and on Indigenous peoples brought out much that is hopefully new to the store of information and opinion on these topics. Neither chapter was the product of a single author, and each was shown to several people for comment and feedback. In these particular histories, some persons will experience sadness or anger from what they read, even if they agree with it, and especially if they do not. These are topics that do not yet lie entirely in the past. It's one thing to decide on chapter headings, but quite another to choose and verify instances worthy to be included in a history of this great institution, and to make them interesting. The court is, of course, an enduring institution of government, a place of sometimes painful encounters for litigants, lawyers and judges, and a workplace. Hopefully what's been published will enlighten and entertain, not that every reader has the same interests or the same sense of humour. Readers can be assured that the book is not a hagiography, nor does it subscribe to the so-called Whig view of history that perceives an ever-unfolding progression towards enlightenment. This said, the final chapter, written by Chief Justice Bell and myself, takes an appropriately optimistic view about the court as it enters its 3rd century. Indeed, readers can be absolutely certain that nothing but good things are recorded about the court's history since its 18th Chief Justice took office in 2021. As you'll discover, the book is thematic, apart from its opening 2 chapters. I wish particularly to thank the contributors who joined me in writing or co-writing several chapters. Mark Leeming, who shared the chapters on the court's 2nd century and its civil jurisdiction. Virginia Bell, who wrote the chapter on famous criminal cases, and Margaret Beasley for the chapter on vice-regal intersections. John Baston, who co-wrote the chapter on Indigenous relations, with significant assistance to us both from Dina Yaya, Andrew Smith and Tony McAvoy. Ros Croucher, who prepared the chapter on women along with Larissa Reed. Tony Caneen, who wrote the chapter on Empire and War, along with Paul Brereton. Robert McDougall and Larissa Reed for the chapter on buildings. Daniel Yazdani, who co-wrote the chapter on ceremonies, robes and symbols. The chapter on art had several contributors: Andrew Bell, John Sacker, Sophie Howard, and the 2 editors. You'll find a fairly detailed index and a table of all of the court's judges, but there is no exhaustive table of names. This is in part to encourage those judges and former judges who have not been directly caught up in some imbroglio mentioned in the index to read the whole text and the footnotes very carefully. Persian carpet weavers are thought to insert a deliberate mistake in their work because only Allah can achieve perfection. This has not been necessary for constant guardian changing times because of the certainty that this book will contain flaws. Hopefully they're minor and will be attended to if the work ever goes to a 2nd edition. Alternatively, any reader who lingers around to 2124 can be confident that everything about the first 2 centuries will be put into its proper perspective in the long run. Your editors wish to thank their families for their patience and many helpful suggestions made along the way. Chief Justice Andrew Bell has played a very active role in this project. Andrew read and reread all chapters, offering many acute comments. As already indicated, he's a co-author of the final chapter. Discussions with him have confirmed just how much the role of a modern Chief Justice is evolving. His scholarship, enthusiasm and support are most appreciated, so too the hosting of this launch. We all know that these events do not happen by themselves. Thank you, Edwina Chapman, Nick Sanderson-Goff, Jerry Thorovsky, Nathan Gray and other members of the court staff for all your efforts in making this such a happy and memorable celebration. Thank you.
Thank you so much, Keith. I should have said that one other dimension of the bicentenary is that from after the bicentenary on the 17th of May, it's hoped that each newly admitted lawyer for the rest of this year will receive a copy of the history on their admission. It is important, vitally important, in my view, that the profession knows its history and the history of this court. That is one way we are seeking to achieve that, and I hope many people in this room will take the same view about spreading the knowledge of this history and the book to their professional colleagues. So thank you again, Keith and Larissa. Now we move on to stage 2, which is shorter, but equally exciting. I've already outlined what is outside, and after Her Excellency speaks, I will ask her to formally launch the gallery. We'll move to that door where there is a ribbon. Perfect timing, Sophie. Which Her Excellency will cut with a blunt pair of scissors, which will rapidly be removed to a secure box. But I do invite you all to, after the ceremony, apart from buying your 6 or 7 copies of the book, to enjoy what has been installed. We're very proud of it, and it's, as I've said, a public component of this civic institution. So, Her Excellency, the Governor.
Thank you, Andrew. When the Chief Justice referred to the exciting part of the proceedings, he wasn't referring to my speech. When he referred to the short part of the ceremony, I think he was definitely referring to my speech, or at least hopefully so. But as from today, that dull grey carpet and the off-white walls, ubiquitous in public buildings built in the 1970s, especially this one, have been banished from Bell's Kingdom. In its place, when one walks out of the lifts, there is an assault on one's historical senses as has never occurred before, at least so comprehensively, in the court's history. Starting from the collection of the sketches of famous cases, the Rafty collection, you'll find that when you come out the lifts, turn left, the door to hopeful judges will still be locked to you, but you can stop there and view those. They include sketches of the Cairns and Judy Morosi defamation trial, for example, and the trial of the Murphy brothers for the murder of Anita Cobby, of just 2. The history wall, which is, sorry, I should say before you get to the history wall, you turn around, look to your right, and you find something I'd never seen before, a winter gown. David Hunt. It was David Hunt's winter gown. So it's black, it's got fur, and a red piece of material draped over it. I think it's called a sash, but looks like a red bit of material. I'm assuming he had that before this building was built, and he was over in the old St James building, for which air conditioning and modern and ancient architecture were not happy partners. So you've got the robes. You turn, keep walking. On your left, you've got the history wall. This is a great love of the Chief Justice, actually. I think he sort of, loved Lego when he was a little boy. This history wall captures every aspect of the court's 200-year history, and it is actually a masterpiece of a consolidated narrative in both text and in images. And it's colour-coded to attract both the young and the curious, and those like the Chief Justice when he was a little boy and loved Lego. There's also the wonderful Simon Fieldhouse portraits of the judges. Simon has generously donated that particular sort of mini portraitures to the court. Can I suggest to all judges, present and past, that it's actually much kinder to yourself, if you want to keep a little bit of self-esteem, to actually look for your name rather than your actual image in a particular portrait. But it is what is now officially, I think, can be called the Courts Gallery at the western end of the building, that the history of the court the judges, the cases, the architecture, both exterior and interior, the commemorations, including the replica of the 150th anniversary stamp, a reference to which was made earlier, which it is a replica because I can tell you it's actually bigger than even a Government House envelope. But that's where you're going to find all of that all together in the most wonderful series of images. To call the images and the way that they've been curated eclectic, as the Chief Justice told me at least 10 times earlier today, would be an absolute understatement. It's certainly too eclectic to be charming, and it's definitely sufficiently eclectic to allow for revision, as actually happened this afternoon as the Chief Justice was explaining to me its eclectic character. Eclectic, absolutely, but it's actually deceptively so. As a viewer, rather than being forced to take a backward step just to get some sense of the whole thing, of what's up there, two things actually happen to you. First, there are certain photos on the wall that are immediately striking. For example, there's one of the Honourable Murray Gleeson, and it's taken with that sideward glance that most of us used to prefer to avoid. And I think if you could just look this way at the current Chief Justice, you'd all understand exactly what I'm talking about. But then, as one goes closer to look at that or one of the other images on the wall, you're immediately attracted to the one next to it or the one below or the one beside it. And certainly as I was looking at it without the crowd, so everyone's going to have to come back at some stage, you identify an image and you think of a story that you know. I mean, there's an image of former Chief Justice Jock McClemens. And of course, there is the apocryphal story of Clive Evatt, which I'm sure you know, when he actually used to refuse to acknowledge his presence in the court. And, you know, Jock McClemens just stood at the bar table and looked at beyond McClemens and said, is that the Honourable Justice McClemens at the bench? I mean, can you imagine doing that to current Chief Justice? I mean, that would be just extraordinary. And just one other history matter struck me as we sat here. I don't know how many of you could actually see the copy of the Chief Justice's copy. It's got these things called yellow post-it notes. Apparently, some barristers, and I still don't know whether those barristers in the room still do this, they used to look for the judge. Perhaps I should add this first. In the Court of Appeal, we used to call them not post-it notes, we used to call them tippy notes, right? But the barristers didn't know that, and they used to look for the appeal book with the most post-it notes on it, trying to pick out which judge had the star, little knowing that it was actually the tippy that had put all the post-it notes on it. But that's just a hint if that still goes on. But this is a really important occasion today, and what has been done to commemorate the history of the court is extraordinarily important. But as with any history, nothing should be taken for granted. And what this bicentenary has done, it has provided the occasion for the court to remind itself of its purpose as the third arm of government, providing a buffer between the citizen and the state, maintaining the rule of law in its civil society, and serving the people without fear or favour, affection or ill will. As the title to the bicentenary book states so eloquently and so accurately, Constant Guardian, Changing Times.
Well, thank you, Your Excellency. I now invite you to accompany me. We'll go to the the Phillip Street entrance where the blunt scissors will be applied.
Thank you.
So I invite Her Excellency to officially launch the Supreme Court Gallery.
I now launch the Supreme Court Gallery.
Well, that concludes the ceremony, so please come in and enjoy and absorb. Thank you for coming.
Okay. Oh, so wonderful book.
Had so much fun.
Oh, yeah.
Thank you.
Wonderful.
You're heading off somewhere overseas shortly?
Tomorrow. Oh, no, Friday.
Holiday?
There will